started. Very nice to see all of you here today. My name is Andrew Cohen. I'm the Associate Director of the Rehnquist Center on the Constitutional Structures of Government, which is the sponsor of this morning's conference on, or today's conference on immigration and federalism. The Rehnquist Center was founded in 2006 as a nonpartisan center to promote the study and understanding of the constitutional structures of government, which were central to the jurisprudence of the late Chief Justice Rehnquist. Our first panel this morning is devoted to the constitutional dimensions of immigration federalism, and I'm very pleased to welcome our distinguished panelists here this morning. Our first speaker is David Rubenstein of the Washburn University School of Law. Our second panelist this morning is Joseph Landau of the Fordham University School of Law, and our third panelist is Hiroshi Motomura from the UCLA School of Law. Each of the panelists will begin with roughly 15 minutes of prepared remarks. Each of the panelists will then have a few minutes to respond to the remarks of the other panelists, and then we'll open things up for questions from the audience. With that, I will turn the microphone over to Professor Rubenstein.
The hypotheticals that we as law professors have been talking about are happening. Questions about what if have become what now. The wins, the losses, the draws of the last 4 years will take on different hues in the next 4. The political safeguards of federalism, the idea that states' rights would be checked in the political process, in particular in Congress, are coming face to face with the dominant model of administrative law, presidential administration, where law is increasingly made and decided in the White House. In short, I cannot conceive of a more timely symposium. I really couldn't think of what we could do today that would be more on point. And I can't thank enough the people who organized this event and brought it together, and for welcoming me to be on this distinguished panel and to be with all of you and to hear from you today. I want to explain my title, Immigration and Federalism Cake, and some of my thoughts on having it and eating it too. Federalism, it has some famous baking metaphors. On the one hand, layer cake federalism captures the idea of distinct powers in the federal government on the one hand and on states on the other. More generally, there's the model of marble cake federalism, which envisions an overlap between the federal and state governments, where they're sharing power, sharing responsibilities, sharing duties. And in immigration in particular, we have a little bit of both. We have this sort of semi-layered cake, semi-marble cake. And so I'm here really to talk about, just to understand how these models of federalism translate into immigration, and with reference to things that are happening today, with also reflections on what has happened over the past several years. Why this matters today is because we have a mix of states, and we use the terms, restrictionist, which capture some of the laws that we see, at issue in Arizona and Alabama. And then on the other hand, you have states and localities pursuing integrationist measures, which offer a sense of welcoming or belonging to immigrants. And all the while, there's no consensus on 3, I think, of the most important questions in immigration today, and have been for the last several years, which are, what to do about our broken immigration system, in particular undocumented immigration. Who decides what to do about it? Is it the president? Is it Congress? Is it the states? Is it the courts? And the other question is, how are those issues to be decided? Right, if the president's deciding, then perhaps the doctrines of administrative law should govern. But if it's Congress, the decisions have to be made through the finally the broad legislative process. And so there's no consensus on any of these questions, which lands us to today. Complicating matters further is the idea that immigration is exceptional, where the normal rules of constitutional law don't apply in the same ways. Sometimes they do, and sometimes they don't. And this is true not only for constitutional rights, but also for separation of powers and for federalism. And they're all interrelated because they link to a common set of rationales: sovereignty, foreign affairs, national security, institutional competence. And so there are trade-offs when we talk about whether or not immigration should be exceptional for one purpose or another. And there are trade-offs between the models of federalism that I introduced you to, marble cake and layer cake. And I also just want to give credit, not for this diagram itself, but to Hiroshi Motomura, who used a triangle for a similar effect. I call it a Hiroshi triangle. But it nicely captures the intersections. And as we'll hear about today, Hiroshi and I are both quite interested at the intersections of these constitutional dimensions. And so even though we're focused on federalism today, the point is that it's not just about federalism, because how federalism questions are decided will have spillovers into these other constitutional dimensions. So you'll forgive me for the mixed metaphors, and perhaps for the pun with the Trump. But my focus today will be on preemption, the idea that federal law trumps state law. This is what the Supremacy Clause provides. It says the Constitution and laws made in pursuance thereof, and treaties shall be the supreme law of the land. I should note what it does not say. It does not say that federal law is the supreme law of the land. And in fact, that will be a lot of what my comments are directed to today. So with regard to the Constitution being the supreme law of the land, this is probably fits in the most best with the idea of layer cake federalism, and in immigration in particular, the idea that immigration regulation is exclusively for the federal government, and it's not for the states. Now, the Constitution doesn't say that, but the way the Constitution is structured and the way that it's been understood in the immigration context has created this doctrine of federal exclusivity. Now, the line between what is exclusively federal and what is not exclusively federal has been explained by the court to turn on whether the regulation at issue at the state level qualifies as quote-unquote immigration regulation or whether it qualifies as alienage regulation. Now, as certainly scholars who are invested in this field understand quite well, the line between what's an immigration regulation, which is generally defined as the laws governing the admission and exclusion of immigrants from the country, it's not a hard separation between alienage regulation, because any time that immigrants are regulated for, let's say, in terms of giving benefits, of welfare benefits, or in-state tuition, or any type of quote-unquote alienage regulation, that can have an effect on migration decisions for immigrants to come into the country, and if so, which state they want to go to. So it's a very fragile distinction that this structural preemption idea rests upon. And so there's some important trade-offs that we see in the cases as they're developing because of this. If you conceive of immigration regulation very tightly as being very limited to the admission and the exclusion of immigrants, that will give you one set of responses when you have states like Arizona with restrictionist laws, or perhaps even states like New York and California with more integrationist laws. If the exclusivity applies to laws such as Arizona's, which are pushing or encouraging immigrants to self-deport, well, what about for states that are pulling immigrants into the state either by giving benefits or a sense of welcome? And if this layer cake or structural preemption is, it basically could cut both ways. Also, there's questions about empirics. Do these restrictionists, do these integrationist laws actually push and pull immigrants into their communities? And even if there are some pushes and pushes, which one matters? Is it enough if immigrants move to a different state? Or do they have to be moving to a different country to trigger this exclusivity principle? And these are questions that remain open today. But the Supreme Court, for its part, has been moving away from the exclusivity principle. In the recent case of Arizona and in Whiting, the challenge was that Arizona's laws were structurally preempted, and the Supreme Court didn't even deal with that question. And so it seems as if the court is moving away from the idea of the exclusivity principle with respect to immigration regulation and moving to a marble cake model, increasingly so. Now, in the Supremacy Clause, it's the provision which says laws made in pursuance of the Constitution shall be supreme. So it clearly includes valid federal statutes that could preempt state law. And for those, well, certainly this is familiar to all to us professors and who are studying this, but if you don't remember from law school, or if you haven't gotten to it yet if you're a student, there's a taxonomy, there's a whole sort of array of ways that the court deems whether Congress and the statutes have preempted state law, and they range from express to implied, and implied has different forms, where it's not expressed in the statutes themselves, but there's field and conflict and possibility and obstacle. These are all different ways that the courts construe federal statutes as preempting state law. Now, in terms of the trade-offs, it really depends on whether or not a state is deemed to be preempted under this preemption doctrine. Depends a lot on how the court engages in statutory interpretation. Does the court engage in a very textualist interpretation, or is the court going to pull in a more purposivist? What is the spirit of the statute? Because if the court at the end of the day is trying to figure out whether Congress intended to preempt whether it's an integrationist or a restrictionist state law, how the court goes about statutory interpretation can matter a great deal. The court also sort of sometimes says that there's a presumption against preemption. And that's consistent with the idea that Congress should be making the choices about when state law should be preempted or not, and what the preemption does is it puts the onus on Congress to be clear in its statutes when it intends to preempt state law. However, in the immigration context, partly owing to the idea of the layer cake, the remnants of the layer cake structural preemption model, the court sometimes seems to be putting a thumb on the scale in favor of preemption when it comes to immigration. And with regard to implied preemption, it's the same thing. Is it a textualist, is a purposivist approach, is a presumption in favor or against? But at the end of the day, these implied preemption doctrines, including specifically, has Congress occupied the field, or does the state statute or the state regulation pose an obstacle to the purposes of the federal statute? Those are entirely questions of judgment. They're questions of degree, which means it's really up for the courts to decide and for litigants and advocates to press the court to make decisions about how broadly or how narrowly to construe these doctrines. And the point I want to emphasize is that it will cut both ways, or maybe it should cut both ways. Now, with regard to the Supremacy Clause, again, laws made in pursuance thereof, the Supreme Court has interpreted this to mean federal agency regulations. So agency regulations that go through notice and comment rulemaking, they're binding. So they act a lot like laws. They look a lot and feel a lot like laws. And for better or worse, the Supreme Court said that binding agency regulations can preempt. But what about non-binding executive policies? The Morton memos that were at issue in the Arizona litigation, DACA, DAPA. Those things did not go through notice and comment. And the question is, why should those have preemptive effect? Elsewhere, I've written at length about this paradox, called the paradox of administrative preemption. I'll explain it to you just briefly. Essentially, the federal government, and I think that this must be one of the best examples of the federal government trying to have its cake and eat it too. For purposes of separation of powers, the federal government is insisting, and did insist, that things like DACA and DAPA are not law. Because if they were law, they probably would have had to go through notice and comment rulemaking. And if they were law, they arguably would have been a violation of the separation of powers, at least if you think that Congress is the lawmaker. So with regard to separation of powers, the federal government is saying, this stuff is not law. But when it comes to federalism, the government's insisting that it is law. Remember, look at the language of the Supremacy Clause. They're saying that this is law, it's capital L law, even though this stuff is not binding on either the agency itself or not binding on the public or how it's supposed to bind the states. And I think that this, again, is a paradox. It's never been explained by the Supreme Court. It's never been justified. It just is. And when you put it all together, the many ways that state law can be preempted structurally, again, that's the layer cake. The idea is that the Constitution itself divvies immigration power in the federal government exclusively with regard to the admission and expulsion of immigrants. And then you have statutory preemption where Congress is making the preemption decisions. And then you kind of go down another rung, thank you, to binding regulations. Again, that's agency regulations that go through notice and comment rulemaking. At the very end, you have non-binding policies like DACA and DAPA, and for example, the memos that Secretary Kelly under the Trump administration just put out earlier in the week. And so where are the political safeguards of federalism here? You don't see it in structural preemption. That happens automatically by the structure of Constitution. You see it most with statutory preemption, but the problem is we're dealing with statutes that were all crafted and dated prior to this whole big immigration revolution at the sub-federal level we're seeing today. Binding regulations, the agencies are not politically beholden to the states, and when the executive doesn't go through notice and comment rulemaking, where's the protection, where's the politics? It's not. It's being decided by unelected officials. And if it's happening by the president, that's another thing. But again, that's not what the political safeguards mostly had in mind. It was mostly that Congress would decide whether or not to have a uniform federal policy or whether to leave a decentralized system for experimentation in the states. I guess I'll just end, because I know I'm out of time, and maybe I'll do 2 more slides if you'll allow me, with two different preemption models for you to think about, right? Model A would start with a tightly bound exclusivity principle, or maybe there wouldn't be an exclusivity principle at all. Where in Model B, that you have a functional exclusivity principle, which would capture not just pushes, but also pulls that states are creating vis-a-vis immigrants into the country. Number 2, you could have a statutory preemption analysis, which is very textualist. You have with a presumption against preemption. It would reject a freewheeling obstacle preemption, a really tightly bound approach to statutory preemption, or you can have a statutory preemption, which is purposivist, a presumption in favor of preemption, and a much more freewheeling obstacle determination by the courts on whether or not there's a significant enough conflict to deem it preempted. And then you could have a version with administrative preemption, only binding, or perhaps only with regulations that go through notice and comment. Or you could have one where even guidance can preempt. And I'll just leave on this thought, because I'm sure we'll do more during the question and answer. Which one of these models do you like? I mean, are you answering that question with reference to the end state, to the consequences that you want? Because you're thinking, well, what will that do for restrictionist laws? Or what will that do for the integrationist laws? Because if that's what you're doing, then you're probably going back and forth. It depends on which law is at issue and what your ideological preferences are. And there's nothing wrong with that. It's just that it's not treating federalism as a neutral principle. It's treating it as very instrumentally. And so what we're dealing with now, and this is the sort of the cake that has been developed over the last few years, is now we may have to eat some of it, and we'll have to find out. Thank you very much.
Professor Landau.
Thanks so much. Thank you for this invitation, Andy. Thanks for having us all here. It's really nice to be here. And I also want to thank Nina Ravine for putting together a really fascinating, really interesting tour for a number of us yesterday over the Mexico border to understand better the work that a number of relief organizations are doing here. So it's really been a really fantastic time here, and the invitation is really appreciated. I thought I might try to take a slightly different approach to the question of federalism, and I really appreciate what David has done by teeing up. If you can't hear me, by the way, just put your hand up. I can't tell whether this is coming through. Okay, good. I really appreciate David's effort to tee up so many different models of federalism, and I'm just going to run with that ball by teeing up a different one. And that is, I want to think about the idea of pockets of decentralization exclusively within the federal sphere. I want to think about how separated powers within the executive branch might actually operate like federalism-style structures. And in that sense, my talk today is about our federal government, if you will. The federalism-like structures that I have in mind exist at various echelons of the bureaucracy, and they function, I think, or can function, maybe should function, or maybe shouldn't function, as laboratories of experimentation, especially where there's discretion on the ground, and that these lower-level experiments can filter up to the higher echelons of the federal government and even be a basis for across-the-board policy. So the theory that I have, I think, is transsubstantive, but I'm going to draw on some immigration examples, some case studies, to try to make this point about the filtering up of laboratories of experimentation by lower-level bureaucratic officials, officials who often have the long-term agency view in mind, officials who often have an expertise based on the long-term practices that they've utilized day in, day out in their ordinary work. As I lay out the examples, I'll also at the end try to say some things about what the status of this kind of federalism model might be, what kind of legal status, what kind of constitutional or quasi-legal or quasi-constitutional status it might have. The idea of the case studies is that they involve lower-level uses of prosecutorial discretion by officers on the ground that have kind of interesting correlations with eventual across-the-board action that is taken wholesale in the agency. And so ordinarily when we think about prosecutorial discretion, about the use of limited resources to make strategic decisions about what resources are really worth using in the enforcement context, we generally think of it as a kind of top-down story. Most commentators and law professors who talk about certainly the most recent executive deferred action programs, DACA and DAPA, see it as a way that the administration tried to bring lower-level agents under control and to get them to adhere to enforcement priorities that had been reiterated time in, time out in previous memoranda. I think that top-down story makes a lot of sense. It's surely correct. But I want to ask whether the reverse might be true as well. Could there be groundswells of decisions by frontline officers who are imbued with discretion and who can draw on that discretion to provide learning opportunities to the higher-ups? And could these laboratories of experimentation be influential on the government writ large? So the first example I want to give involves the foreign-born partners and spouses of LGBT U.S. citizens and lawful permanent residents, particularly during a years-long period leading up to the Windsor case, when the Supreme Court struck down a core provision of the Defense of Marriage Act that refused federal recognition to same-sex marriages, including, of course, immigration benefits. During this years-long period, many couples, some married, some not, who were unable to avail themselves of family-based immigration benefits because of the Defense of Marriage Act, nevertheless received favorable discretion by lower-level bureaucrats who were willing to use the power that they had, including delaying cases, ordering those cases to be administratively closed, not initiating proceedings, removal proceedings in the first place, or granting deferred action to foreign nationals in relationships with U.S. citizens or LPRs. The cases proceeded one at a time, they were slow going, but attorneys were often successful in persuading their bureaucratic counterparts or judges to favorably exercise discretion, especially when another official had done the same kind of thing in a prior case or even in a different jurisdiction. Now, interestingly, in the wake of many, many examples of this, the Obama administration did take across-the-board action, directing lower-level officers in October of 2012 to exercise discretion favorably to foreign nationals in same-sex relationships with U.S. citizens and lawful permanent residents. Now, Congress was also considering a bill at this time that would have done the very same thing, more formally, of course. Now, I'm not making an empirical claim here. I'm not trying to say that line officers caused this, or certainly that they thought of this first, but they did act first, and that's what's interesting to me. Another example concerns parole in place for military families. This is also a story about bottom-up influences and other kinds of separated powers within the executive branch. Many of you know about this example through the work that Margaret Stock has done and her advocacy around the work of foreign nationals who want to adjust their status through marriage, but who can't, really effectively can't, because they were not inspected or paroled at entry. These individuals ordinarily, to adjust status, would have to do so through consular processing. But that requires leaving the country, and upon leaving the country, for individuals who have accrued unlawful status, as many of these individuals had, they then become subject to up to a 10-year bar from re-entry. Now here again, solutions began to emerge at the ground level. When benefits administrators within CIS started granting parole in place to to a foreign national, or line officers within ICE, or immigration judges within EOIR would fashion other kinds of creative solutions, such as granting deferred action to the foreign national spouses of United States military service members. But it was really actually here the Defense Department that played a big role in the wake of this kind of bubbling up of individual decisions on the ground to try to put pressure on the DHS so that DHS would understand why this was really an issue of military preparedness for those service members, particularly overseas, who were worried about the consequences that their loved ones would face owing to their unlawful status. So again, experiments on the ground begin to filter up to the higher echelons, which eventually, I shouldn't say leads to, but is coterminous with or correlates with an across-the-board policy granting parole in place in these kinds of cases. The next case study, I think, may be more apropos to the current time, because this one actually concerns bureaucratic resistance to top-level policies that really didn't accord with the long-term practices and maybe even the best interests of the agency. So there's a little-known policy in 2003 that was rolled out by the Bush administration, the second Bush administration, that would require the automatic detention of foreign nationals who were ordered removed by an immigration judge. It's called DAR, Detention After Removal. Detention After Removal. It was a 2003 pilot project. And here, enforcement officers actually resisted these new and experimental, if you will, top-down policies for placing unrealistic burdens on the immigration system and undermining well-established agency practices, which is that absent exceptional circumstances, an individual would not automatically be put into detention at the conclusion of a removal hearing, not least so that that individual could appeal that hearing, that decision. Like I said, this was really a shift in practices, but around this time, there was a lot of reporting of statistics, ICE statistics, that 85% of undocumented immigrants would abscond, and that there were roughly 400,000 foreign national fugitives within the US. So this reporting was supposed to be a reason why this policy made sense. There's been very little reporting about this policy. I've spoken with immigration attorneys on both sides, both for the foreign nationals and for the government, and I benefited enormously from a FOIA request that was done by John Bauer at the University of Connecticut. And it seems from these materials and from these interviews that the demise of this program may have been due not only to resistance from the private bar, but also from DHS counsel and other bureaucratic personnel, including immigration judges. Members of the immigration bar believed that the feedback being sent up the chain of command was negative, and that the program failed because it lacked buy-in from the agency's long-term experts. ICE had limited bed space. Requiring automatic detention was overwhelming immigration detention facilities. In Hartford, where it was piloted first, the nearest detention center was actually quite far away from the immigration court, which created all kinds of additional work for deportation officers, making it hard for ICE to comply. IJs were aware of this and were worried about this and took various kinds of action by delaying cases, granting continuances, often scheduling bond hearings immediately so that the foreign national wouldn't be placed in detention during the gap between the hearing, the removal hearing and the eventual bond hearing. Now, unfavorable exercises of discretion, I should say, were exceedingly rare in 2003, but they happened. Immigration lawyers that I spoke with explained to me and told me about cases in which, owing to this automatic detention, DHS trial attorneys were in a position to want to try to work with them more. So I think this case study points differently to the idea of civil servants as a kind of check on top-down decisions that ran against the grain of what they were accustomed to do. We could even maybe tell a story about DACA and DAPA through this lens. If you look to empirical work that Shogo Wadia has done, looking at roughly 700 deferred action cases processed by ICE in 2011 and 2012, the data reveals that the two most common humanitarian reasons for a grant were presence of a United States citizen dependent, that's DAPA, and presence in the United States as childhood, that's DACA. So from that perspective, the 2012 and 2014 programs really reflect an effort to simply regularize a groundswell of case-by-case, lower-level decisions. And I actually think that kind of symmetry between what's going on at the top and what's going down in the bureaucratic ranks could supply across-the-board agency decisions with an important degree of legitimacy. So instead of asking, does this satisfy Chevron step 1, step 2, or under Heckler v. Cheney, is this walled off entirely from judicial review altogether, those kinds of formal, if you will, tests, here the legitimacy of an executive branch program would rise or fall based on its consistency with the best practices at all levels of the immigration bureaucracy. So if we say in administrative law that the executive is home to two different sources of legitimacy, the political, democratic side, democratic will, and the bureaucratic expertise side, I'm saying we should focus on the latter rather than exclusively focus on the former. Okay, so far I've tried to say two things. First, I think it's worthwhile to try to identify possible connections between line officer decisions on the ground and across-the-board programs, and that ground-level decisions can provide these kinds of laboratories of experimentation. And second, I would argue that even if the interplay does not exist, and often it won't, ground-level expertise needs to be more central to the design of high-level immigration policy than it currently is, at a minimum, so that when the high-level policy is announced, it will penetrate the bureaucracy more effectively. Certainly that's a question that many are wondering about some of the new executive orders that have been announced. So more kind of deeply, because we've been asked to think about constitutional dimensions, I think it's worthwhile asking how these kinds of vertical separations of power that I'm talking about might function in more kind of constitutional language. And so I'm going to quickly draw on the two of the recent lower court cases interpreting the Trump travel ban executive order. They're interesting to read because they reflect these kinds of ideas of problems in the vertical flow of how the executive orders were designed and created. They mention confusion in the rollouts of these executive orders. They mention shifting positions within the executive branch. They are very pointed in saying that post hoc statements by cabinet officials or White House counsel's office actually don't count to supply meaning to the unclear terminology of the executive orders. At a minimum, these kinds of moves, or these kinds of things that the courts are saying, certainly don't inspire confidence. But they really also could carry more legal weight, especially as they move, and I think they will move, from the kind of facts section of these opinions into the law sections of these opinions. But we lack a nomenclature for this. We don't have a really developed doctrine around this, but there are arguments to be made. So the Virginia, the Aziz opinion in the Eastern District of Virginia explains that executive orders are ordinarily based on cleared views from expert agencies with broad experience on the matters presented to the president, and that there was no evidence here that such a deliberative process took place. Courts tend to avoid these kinds of issues, though. It's much easier to talk horizontally, right? If you think about really big, important decisions by the Supreme Court that try to push the issue back to Congress using clear statement rules or constitutional avoidance canons. This is really where I think, as law professors and as law students, we're accustomed to seeing judicial review go. But the problem is that Congress may not really be in a great position to fix some of these things. I mean, that was certainly the case, to just go slightly to the side to the Guantanamo context, where in a series of opinions, the court kept telling Congress to fix the problem. Congress reportedly fixed the problem, and the court invalidated what Congress did anyway in the Military Commissions Act in stripping habeas corpus review. Let me try to put this another way. On the one hand, in the travel ban decisions, the courts seem to have no difficulty making it clear that they think the government's legal positions, the position of unreviewable authority, are extreme. But could the courts go so far as to invalidate the ban, given rapid and wholesale changes in executive policy, when those rapid and wholesale changes make little to no reference to longstanding agency practices? Well, maybe they can't go that far. But here's something that the Ninth Circuit said in its opinion in the Washington and Minnesota cases. It said, it's not our role to try, in effect, to rewrite the executive order. The political branches are far better equipped to make appropriate distinctions. For now, it is enough for us to conclude that the government can't prevail in its case. Perhaps the courts can say little More than that, lest they seem to be going outside their proper boundary and almost aiding the executive, not so much in amending the language, but telling the executive how it's supposed to do its work. But regardless, if and when the executive branch ignores longstanding agency practices, both procedurally in these later cases that I'm talking about, and substantively in the earlier examples that I gave you from immigration law, and when it goes outside what the lion's share of the expertise of the agency is, the only other institution that might share that long-term interest is the court. And in that case, the court itself may be more aligned with the bureaucracy than any other coordinate institution. I think that's something that scholars and litigators should be thinking about, that we should be raising, that we should be asking about in the process of challenging or defending these new executives. So I will stop there.
Thank you. Professor Motomura.
So thanks everyone for being here, and it's really a great chance to, as David said, to talk and think about some issues that are certainly very timely. And the axes or the dimensions of immigration federalism have shifted quite a bit as we go from one administration to the next. And so, as David said, I can't think of a better time to revisit these issues and think about how constitutional structures affect how we deal with the role of states and cities. And so let me explain. Start this by going back to April of 2012 and just spend a few minutes, or a few seconds really, just talking about the oral argument in the case called Arizona versus United States, which was as you know, the challenge that the federal government took to the Supreme Court ultimately on SB 1070 from Arizona. And in that oral argument, the Solicitor General of the United States, Donald Verrilli, opens up with, and I'm reading here from what he says. It says, Mr. Chief Justice, and may it please the court. And then as soon as he said that, Chief Justice John Roberts interrupted and said, before you get into that, before you get into what the case is about, I'd like to clear up at the outset what it's not about. No part of your argument has to do with racial ethnic profiling, does it? I saw none of that in your brief. Now, Verrilli replies to that point, quote, that's correct, end quote. And he adds, we're not making any allegation about racial ethnic profiling in this case. And so, now a few minutes later, Donald Verrilli actually brings up what you characterize as the potentially profound and disproportionate effect by race and ethnicity on the enforcement of SB 1070. And he observed that 2 million Latinos live in Arizona, but only 400,000 of those are unauthorized migrants. But Justice Scalia cuts him off. And Scalia says, well, what does that have to do with federal immigration law? I mean, it may have to do with racial harassment, but I thought you weren't relying on that. So this is a very interesting exchange, because I think a lot of what's going on in that particular case, and perhaps in the political debate today, has to do with a mix of exactly what structures there are to make decisions, combined, mixed with the question of what effects it has on people. And certainly, it's a question of where the law meets the politics here. So it's worth spending some time trying to unpack that. And a lot of what I'll lay out today comes from a book I put out in 2014 called Immigration Outside the Law, where I discovered in writing that book that although it ultimately does address these questions of who should decide and the questions of immigration federalism, it was very difficult for me anyway to think about these questions without taking a Donald Verrilli type of take on this, which was, unlike his initial answer, which was, no, this doesn't have to do with racial ethnic profiling, I associate more with his second response to that whole argument, which is that it is actually relevant. And the question is exactly how, why, and what are the limits on that relevance. So I start with the idea that there is this notion of exclusive federal immigration authority, exclusive federal control over immigration and citizenship. Now that's been a long time in coming. I mean, it didn't really emerge until after the American Civil War. I think it's no accident that it didn't emerge until there was a Civil War to talk about what it meant to be a person, what it meant to be a national citizen instead of a citizen of various states. So I start with that principle, but I have to acknowledge that in thinking about that principle for a long time, it's been really hard to apply it in a very reliable or at least principled way, because you do have this distinction that David brought up between immigration law and alienage law, and it's hard sometimes to know where one stops and the other starts. In other words, sometimes states have tried to get directly into the business of immigration enforcement, but a lot of times states and cities get involved more in things like housing and employment with the idea of maybe people will self-support. So to me, if I do start though with the principle of exclusive federal authority, I really have to think about how the immigration system works in this country, at least the way I see it. And, you know, and I want to acknowledge, as I say this, that not everyone here in this room may agree with my view of how this development system we have, but I just want to be upfront about what my view is. And I think we have a system in this country that's very selective in who we admit to this country. We prefer a lot of different types of people, but it's very difficult to immigrate to this country to work if you don't have a college degree. And under that circumstance, but in a circumstance where the country seems unwilling to, or has been in the past, unwilling to enforce immigration laws against people who do come to work without a college degree, and there are millions of them, then that means that the system we have is one of selective enforcement. And in a system of selective admissions and selective enforcement, what really matters is discretion. It's very vast discretion. And discretion creates this tremendous potential for discrimination. And that is the discrimination that Donald Gurley was talking about, or at least expressed a concern about. And there's an empirical question about how widespread that is. But I mean, I think there's enough evidence that it is something to be concerned about. And so what I have here then is a system in which a lot of the point of, or one of the challenges, I think, for an immigration system that is not the system I would have designed, but it's a system that we have, and it's a system where a lot of what actually happens is not what Congress has written in the laws, but rather what actually happens on the street with regard to enforcement in the exercise of discretion. And it's really kind of, I guess, what you call a principal agent problem. In other words, Congress makes the laws, but at one level, but what actually happens poses this challenge of knowing what happens actually, and knowing whether discrimination takes place that's hard to detect. Even if you detect it, it's hard to remedy. So in that sense, my own conclusions about preemption is that it's very important that it serves a prophylactic function, and I thought that what the federal government did in the Arizona case was to step in a situation where the concern was that laws that would seem to be neutral or seem to be merely enforcing law, federal immigration law, might be used in a way that was discriminatory. And this is not unfamiliar in the law. I mean, I think one of the reasons that we don't like, we strike down laws as a way for vagueness is because, not because we want, just because in principle or in theory we want laws to be clear, but because we don't want police officers to decide who they think is doing something bad and who's doing something that's okay. Miranda Warnings is an example of, I guess that's another Arizona example. Miranda Warnings, I mean, there's a lot of theoretical debate about whether it goes beyond what the Constitution requires or not, but the point, I think, is that it reflects the philosophy that we ought to have police saying you have the right to remain silent and things of that nature, because we think that will prevent situations where constitutional violations are committed without our ability to detect it. And so I think of preemption is really having, it ought to have the most teeth when it really shifts, when it takes power away from actors, government actors at the state and local level who may discriminate in a way that's hard to detect and hard to remedy. And what this does is that it means that the preemption actually shifts the risk of uncertainty from plaintiffs to states and localities. In other words, that because you might be discriminating against in a way that's going to be hard for you to bring a lawsuit later, we're going to keep people who might be doing the discriminating from having the power. It's in a sense, preemption provides an oblique protection, I think, in Arizona against state and local discrimination. Now, admittedly, it manages doubt differently, right? It means that And I want to acknowledge the concerns about that in a second. But again, the key here is to really tie preemption and immigration federalism to a substantive view, or at least a certain take on what actually happens in immigration law. Now, that I think has some implications here. One of the obvious implications is that the lack of preemption, or the strength in which preemption is seriously applied, some would say some things is going to be much more preemptive in an enforcement situation than it would be in granting state tuition to undocumented students, for example. And the test really there is there a person who's been discriminated against, who would have standing in court to complain about the state and local measure? If the answer is yes, then I think that my view of preemption suggests that state and local laws ought to be preempted, because there's someone who might be able to bring a claim against racial profiling. But if there's no one who's going to be able to bring a claim that they have to pay someone more tuition because there's some state tuition for undocumented students, if there's no one to bring that sort of claim, except in the most diffuse way that is not granted standing in the court, then I see much less fight for preemption. Now, let me anticipate a few criticisms. Actually, I don't anticipate that, because David has written 30 pages about what's wrong with my book. So it's okay. But we've been friends with him. But I even put him up to writing this 30-page critique because it's kind of my most multiple personality exercise of understanding that one can critique what I said. And so I think that I think that this goes back to what he said earlier, which is I think that the way I'm setting up this view of immigration federalism, it really depends first on what I think, or what anyone thinks, what you think federal law is. Now, I think it's clear that in my view, that federal law is not just what Congress says, and in fact not just what's in the Federal Register, and not just what's in executive orders. It's really what happens, how people in the community experience federal law. In other words, I'm very focused on law in action and not law on the books. And I think that one of the concerns here is that some federal law is more law-like than others. And I concede that there's some federal law that's certainly come under attack is not really counting. It's too informal. It didn't go through the proper procedures. And I think we saw that actually with the Fifth Circuit decision in the DACA case, saying, it should have gone through notice and comment. It didn't go through notice and comment. It doesn't really count. And I can see that one can make those criticisms of federal law that I think ought to preempt potentially discriminatory state and local laws. But I think that the remedy there, if the federal law doesn't count, is really to attack that federal law directly. But but I'm not going to presume that the federal law doesn't exist unless it's shown not to exist. And I think that maybe I want to identify a premise that I just need to acknowledge. And this, again, I'm kind of putting this out there in case you disagree with it, but I really think that given the federal exclusivity on immigration, at least as a general principle, that what that means is that federal law, that as between the sovereigns, the federal versus the state, it's given over to the federal government to make the law. And unless it's shown not to be law, and I'm obviously using a very broad definition of what law is, but if it is law, then it's not the business of the state to question how it's made. In the same way that I would, this is maybe only a loosely applicable precedent, but I think it's an interesting one. It's one that has nothing to do with immigration law, but has to do with the doctrine of Erie Railroad versus Tompkins, some of which you hope from first year law school you never hear about again. Erie Railroad versus Tompkins, I think, stands the proposition that if it's for the state to make the law and not the federal government, then it doesn't matter how the state does it. And by the same token, if it's for the federal government to make the law, I'm not sure it matters if the state has a choice in determining what internal processes the federal government needs to adopt it. So that's one. The other thing which I want to acknowledge too do with another part of what I'm laying out as my immigration federalism, because I think, as David points out, in his critique of this, that it's not only am I making some assumptions about what is law and what is therefore preemptive and displacing state and local law, but I'm also adding this wrinkle which says that the function of preemption, given this immigration system that we have, is the function of reflecting some substantive values. Okay, so I think the objection to this, which he articulates quite well, is that what I'm really doing is I'm trying to shift the content of equal protection law. In other words, equal protection, discrimination claims under the 14th Amendment or the 5th Amendment is applied to the federal government. Equal protection, in other words, you need to show not only discriminatory effect, but also intent. And so what I'm really doing here is I'm saying that federal government, in a way, I would say compromises here. It creates a compromise rule that says we think that the burden of proving discriminatory intent is too great, and we're not going to go all the way back to just showing discriminatory effect. We're going to split the difference by saying if there's a risk, substantial risk that you're going to discriminate, we're going to essentially not allow you to exercise that power. I concede that this is something that, in some ways, I think that we see elements of this in some of these decisions on immigration preemption that strongly seem to be influenced by some of the evidence on discrimination. But I concede that it represents a view of preemption that takes claims that would be losers because it has discrimination claims and turns them into winning preemption claims, not because someone is called as a discriminator, but because the person who might discriminate is the power taken away from him or her or it as an agency. But in that regard, I think what I'm doing is a bit of an intervention into what I think is the law of discrimination in general, because I think the divide or the gulf between discriminatory intent and effect as a standard is a very great gulf, and I'm trying to find some way to really cycle back into discrimination law in general and really rethink the question of having a law of discrimination that doesn't turn on whether someone is being called a racist or not, because I think the stakes are too high and inappropriately high in that context. Okay, so I'm really out of time here, so let me just get back to another theme, which is immigration exceptionalism, which is I think whether, I've been concerned about immigration exceptionalism for a long time, and so, but I've also come to believe that a lot depends on what level of generality that you want to ask the question. I mean, I think the immigration is exceptional in the sense that I think the system that we have now and the view I'm expressing of immigration federalism would not be necessary in a system that was more transparent to start with. In that system, preemption wouldn't have to do the work of either transparency or keeping power from actors who might act against the rule of law. I think that there is a unifying theme that makes this non-exceptional, and that's non-discrimination principle. I want to acknowledge that a lot of this is really being put to the test today with sanctuary cities and cities that don't want to use this word sanctuary, but are doing things that are very similar. And I also want to acknowledge what Joe was saying with regard to sort of line agents doing things that are experimental, but I would also say that works if there's a certain degree of transparency, which is sort of what I'm going for. To that extent, I'm hopeful. At that level, I hope that I'm trying to take into account what I think is the importance of the histories, in some sense, the important history of immigration law, and at a higher level of transparency, uniformity, and the rule of law. And accountability at that level to say that immigration should not be exceptional. So it's really a question of how you ask the question. So let me stop there and welcome the discussion.
Thank you very much. So we'll begin just by offering each panelist 3 minutes or so to reflect on the remarks of the other 2 panelists, and we'll just go down the line. So we'll start with Dave Rubenstein.
Okay, thank you very much. I don't even know if I need 3 minutes, but I'll see how it goes. I want to see if I can tie in a question, which I think is a hard question. But I want to tie in some of the comments that Joe made and what Hiroshi made and to some of the comments that I made. Now, as Hiroshi mentioned, he does take a very expansive conception of law, and that does a lot of work. Depending on what law is, what federal law is, it governs whether or not state law is preempted by that federal law, whatever that federal law is. So the broader conception of law will have a very significant effect on what's preempted, and that will include restrictionist laws or integrationist laws. And so Professor Motomura's idea of importing an inequality norm into preemption is one way to deal with that symmetry problem. That is, how do you craft a preemption doctrine which is strong enough, broad enough, robust enough to shut down restrictionist laws like in Arizona, but that would leave integrationist measures in California and let's say New York free from the vortex of what I call black box immigration federalism. The idea being that the black box connotes the idea that you treat the federal government as an undifferentiated whole. It doesn't matter whether it's Congress that makes the law, it doesn't matter if it's the president that makes the law, and it doesn't even matter if it's law, because what you're really looking at is the quote-unquote law in action. And so to get to my question, if you look at the Arizona litigation, the law in action, the Morton memos and the policies, the enforcement policies of the federal government, which did preemption of at least one, maybe two, depending on how you read the decision. What's interesting is that it really arguably wasn't even the law in action. And to explain that requires a little bit of a wind of tape. The reason, one of the narratives, at least why the president announced DACA, and then later DAPA, the first DACA, was because the line officials were honoring the executive's enforcement policies in the breach. You had line officials who were going rogue and very unapologetically disagreeing with President Obama's enforcement policies. So when you have a situation where the enforcement actions, the quote-unquote law in action, was not even reflected in the memos, but reflected in something that was very different than the priorities. It's reflected in officials not enforcing the executive's policies. And so then you have a situation where it's not even it's not the law in action that's even doing the preempting, because the law in action would not have been following most of the time the Morton memos to be implemented. So I think that this is a question that I think for both to think about. And then one other point about equal protection, I've dubbed it equal preemption to capture the hybrid composition for it. And I just want to say there's nothing wrong with that. I think it's important for all the reasons Hiroshi says. There is an under-enforcement of equal protection, and maybe one way to fix that is through preemption doctrine. And so I've only offered a skeptical view of that, why that I think it's unlikely, not that I think it's necessarily a bad idea. I just want to offer a different spin on the Borelli exchange, the Solicitor General's exchange at the Arizona argument, where, Solicitor General Borelli basically backed down and said, no, I guess it's not really about equal protection, it's not about profiling, it's about preemption. And they tried to bring it up again, and Scalia reminded him, no, you clearly said it's not about equal protection. And I think that immigrant advocates were disappointed with that. They wanted it to, the government to put an emphasis on the profiling and the risk of profiling. And what I want to suggest is I agree with Hiroshi that some lower courts looks like they're blending elements of equal protection and preemption. In fact, the Dream Act case, Brewer Dream Act case, which was the denial of driver's licenses to the DACA beneficiaries, might be a really good example of that. And what I want to suggest is, I think that the idea of equal preemption has a better chance of surviving in like a wink and nod kind of way, where the litigants write about all the potential harms for profiling, but don't actually demand that the court make a formalized doctrine, which would really shift what preemption doctrine is, and would really shift what equal protection doctrine is. And I think by Solicitor General Borelli, not engaging the court or not pursuing that claim, I think that might have been strategically right. Because I imagine had the government pushed that claim asking for an exceptional sort of doctrine which was neither equal protection, which was neither preemption, I don't see that a conservative court accepting that. And so I think almost by winking and nodding, it's probably a better way to have those values that Hiroshi is being made than trying to make it into any kind of a formalized doctrine.
David, would you put your last slide up?
Sure.
So, if you're able to do that, I want to respond. I'm going to respond to David's. I think it was your last slide. Maybe it was the penultimate slide.
Why don't you tell me what you're going to say, and I'll decide if I want to put it up or not.
Okay, fine. you don't need the slide. You remember the slide. David put it up. David was the triangle. It wasn't the triangle. It was the.
Stop slow playing this.
It was, he's just trying to get all the mileage he can out of it. So it was two different preemption models, right? It was a model that on the one hand had three characteristics that were quite formal. And it was another model that had three characteristics that were really quite open-textured and functional and unclear. And I believe you ended by saying that this was, all right, fine. So that there was a trade-off between these two different models. And my sense of this, I think it's helpful to have those two. Thank you for trying to speak. I think it's helpful to have those two models up there. But I actually think that in a lot of arenas, not just federalism, and I think it helps to bring those other arenas in here, the constitutional doctrine is moving from that more formalistic sense of things to this much more open-textured sense in which the formal questions are certainly good questions to ask. I just don't know whether those questions have to be the start and the end of the analysis. And within that, it's not totally clear. This makes people upset. People want clarity, they want bright line rules, and certainly understandable, but that may not be a great fit with the complexity of the legal questions that are being brought to the court. It allows for possibilities, I think exactly in the way that Hiroshi spoke about preemption doctrine, and which David just mentioned as well, in which the executive branch can enforce better some kind of constitutional norm that courts, for their own totally understandable reasons in prior cases, have been loath to enforce to their full degree in the way he explained about shifting the burden on the states. And I might even ask Hiroshi whether it's possible that there's other evidence of this. You mentioned the difficulty of showing discriminatory intent in scenarios where there's a disparate impact on one particular group on another, and only a disparate impact without other evidence of intent. But after cases like Romer, that really kind of shift the thought to, obviously Romer is a lot about LGBT people, but it's also really about core questions of animus, and I think an invitation in a way to think about legislative intent, irrespective of whether the formality of LGBT people get heightened scrutiny, putting that question to the side, which would ordinarily be the question that one has to ask in order to be able to do the remainder of the analysis. Now, I think that's good. I think that shift from formalism, if you will, to functionalism is healthy. And David says, you mentioned, well, there's really no, it would be nice to have consensus on these things so that we know what's the status of non-substantive agency rules, that haven't gone through notice and comment or formal or informal adjudication. Maybe okay that we don't entirely know. I think open-textured law is not necessarily a bad thing, and I've learned from both David and Hiroshi a lot about that idea. Finally, your point about the law in action is certainly a good one. But I think what Hiroshi says is also very important, that without the transparency of knowing what those decisions are being made on the ground, it's hard to know what line-level officers are doing. So I'm not sure I automatically accept the idea that these memos were simply honored in the breach, or that the story that we are told about line-level officers just disregarding the guidance coming from the top is necessarily always true. And the case studies that I've tried to flesh out to me are indications that maybe that's not the entire story. I'll stop there.
Yeah, there's lots of, I really want to leave it open to everyone here, so let me just try to ask myself two hard questions I think David would ask me as a way of continuing the conversation. And whether this really goes back to whether this is a question of having my cake and eat it too or not. One question is can I think of a restrictionist policy that would survive, that I would have less concerns about? And the other is, can I think of a sanctuary and I think of a sanctuary policy that I would have concerns about. And I think that to the extent that there's a pro-enforcement policy that is set up in such a way with minimal discretion in who it applies to, then I think that might be something that would that might not be as preemptive. Something that would rely on a computer database, something that was applied to actually every single person living in a community. That might be one. On a sanctuary policy that I'd be concerned about as preemptive, it might be one that said that we're only going to protect people from certain countries. Those are the people we really care about. They hold the balance of power in the city council, and we're not going to care about all those other people who are from elsewhere in the world, even though they're undocumented too. So, I mean, that's just a quick response to that, because I think it's important to fill out exactly what the implications of this are, because this is a moment where, as you know, it's kind of too obvious to say, is that the change in administrations, the question of who has power to control versus state governments, and really the locus of state local activity, that's very, of course, regionally varied right now. That becomes very important, and I think a lot of the things that we've been talking about for years have flipped in a way that is not just going from the more typical range for Democratic and Republican administrations we've seen in the last 20 years, but really in a much further extreme way. So from that perspective, I think that these kinds of sort of hard questions that are raised in the question are important.
Okay, we'll now take questions from the audience. Back here.
Yeah, you guys are familiar with the general principles of the EB-5 visa?
You mean investor visa?
Yeah. From what my understanding is that the investor EB-5 visa basically grants status to immigrants who invest at least $500,000 in the country, bring in at least 10 employees, or employ at least 10 U.S. citizens in underemployment areas, and a host of other economic requirements. It seems to me, in terms of discretion, regardless of the immigration policy, if you've got enough money to get into this country, it doesn't really matter what the employment or what the immigration policy is going to be.
Comments from the panel?
Well, I mean, it's true that the system exists. It's come under a lot of attack and a lot of reshaping. I mean, it's concerns ranging from the point you're making, to concerns about securities fraud. It's been under investigation. There have actually been some very specifically highlighted, cases of abuse. It's true. I'm not sure it's a question of discretion as much as we have these categories created. They privilege people, and to some extent they privilege people with the funds. And in some sense, it's just an extension of the principle that if you have a lawyer, you're much more likely, you have money to pay for a lawyer, you're much more likely to get in. So,
but it's ultimately the same principle. If you've got a lawyer, chances are you're either wealthy and afford it, or you've got access to an organization that provides. It seems to me it's more socioeconomic discretion than anything else.
Right. But maybe the best response I can give you, or the one that ties into the larger conversation, is that I think that I'm talking about a different type of discretion, which is the discretion of individual decision makers, not the discretion that's based on the fact that you have more money.
So if I read the Times right this morning, Steve Bannon said that one of his goals that he talked about yesterday was either dismantling or eliminating the administrative state. Assuming that comes to pass in the next 4 years, then there either are very few or almost no administrative regulations put forth, and there's complete discretion left for government employees other than very, very rough outlines. How do you see that affecting the overall preemption? I guess the other piece of that is they really enforce every new reg means 2 old regs go away, so that we have the shrinking bathtub model. How does that fit with your analysis of preemption and use of overriding federal law to deal with both bad actors and also to have an impact on the federal law.
Well, if I understand correctly, what you'll end up with is less guidance, maybe at all. Certainly less guidance in the form of binding rules. And depending on which version of federalism you think is the right one, whether those guidance documents count as law, if they do, then even those can preempt state law. You know, if the law and action is what matters, then it's however the federal government is enforcing the law. If there's a conflict and the Trump administration wants to bring a lawsuit against either a restrictionist or an integrationist law, jurisdiction, then that could preempt. So it's going to mean a smaller state role. But really what it probably means is going to be entirely up to the White House to decide what to shut down and what to allow to stand. Now, whether that's good or that's the whole cake and eating it too. I won't say whether that's good or bad. I'll just say that that's the likely outcome, that those decisions have been centralized in the White House, for better and probably for better and worse. And so that's what the immediate effect is. Now, if you take a more limited model, the one that I think is better for purposes of preemption, then in order for the federal government to shut down integrationist or restrictionist states, it has to at least go through the notice and comment process, which would involve public deliberation. It would involve, it would slow things down. It would create more opportunity for transparency. Like all of these values that Motomura and others, Hiroshi and others value, transparency, accountability, that will happen more in a rulemaking model, or even better if it happened in Congress. And so it's not really, that to answer like the slide I couldn't get back up there, what effect does that have? It depends on which of those two models will have to adopt when deciding whether or not state laws will be preempted by those guidance, or maybe the lack of guidance.
Him back there.
Yes, thank you so much, Mr. Landau, for bringing to bear the idea that the real lived experience of actual enforcers sometimes creates a groundswell and can act as a check on, top-down rulemaking. My experience as a practitioner has been that, oh yeah, they're a tribe, and they're a self-referential tribe. They have their own rules. They're self-reinforcing. I'm not sure that always means that they bring any real-world experience to bear. I think instead it's exactly the opposite. I think the fact that they pass down legend and lore to each other insulates them from real-world experience. They tell themselves stories all day long. Stories like, one time I exercised discretion on behalf of somebody who had a DUI and went out and killed some other people. They tell themselves stories like, no one ever comes into the country without being inspected and admitted. They tell themselves these stories even though everybody knows they're not true or not realistic or not meaningful. But they tell themselves these stories, and they tell themselves these stories across agencies, so that ICE officials and ICE trial attorneys are telling these stories to DOJ officials and DOJ judges. And they are a self-reinforcing tribe. So that if there's any groundswell, it's coming from that tribal knowledge. It's not coming from the outside and the experience.
Well, thank you for that. I mean, that's it's really interesting. I've been talking with a lot of practitioners about this theory and this idea, and some think it's terrific and it matches the experience they have in interfacing with the bureaucratic ranks, and others think that it's far-fetched and fanciful. And it goes back to something Hiroshi said about the kind of geographic variation that exists, particularly, I think, in immigration bureaucracies, and the likelihood of success that a claimant has. It's almost kind of a roulette wheel. Your point, though, about the idea that the lore or the story within the agency becomes kind of self-referential and just feeds on itself is a big problem for the theory that I'm putting forward. It also could have all kinds of, it could even potentially need support
some of the most recently announced executive orders to the extent, of course, that during the campaign that President Trump received the support of various immigration unions, enforcement unions, et cetera. So it's a big problem for my theory. I lay this out elsewhere in a longer law review article, and I try to say that what's necessary is a kind of interplay between the ground and the top, and that through that interplay, better policies get made. But I absolutely have to accept your criticism and your point that it could, not only that it could lead to bad things, which is not even what you're saying. I think what you're saying is, but that the long-term lived experience has nothing to do with the real world in action, but has to do with the made-up or fantastic idea of how that law operates, which is false. And I take that and accept that, and I appreciate that, and I'm going to think about that and struggle about how to try to integrate that into what I'm saying. Mike?
All right, so I want to pick up on the discussion between David and Hiroshi about, this is I understand it, about whether or not federalism plays out the same way for state restrictionist policies versus state sanctuary or integrationist policies. And I wanted just to throw out a problem of reaction to the now that you mentioned Filer Doe, and obviously one of the most obvious reading of Filer would fit pretty closely with Hiroshi's argument that anti-discrimination principles are very important here when we talk about the role of states. But I wonder if there's another way to look at Filer and some of the other state alien cases where state measures against immigrants were struck down, as well as the federalism cases like the recent Arizona cases, and that if the Supreme Court is actually promoting a kind of division of labor, not specific to it may be informed by anti-discrimination, but what the Supreme Court is really saying is we want states to worry about the people you have, regardless of their status. And the federal government will worry about immigration. The federal government might screw it up, but that it might not be specific about, the federal government might discriminate as well, and in the past, at least until the recent Washington, Minnesota case, it wasn't clear that the courts would ever stop the federal government out of discrimination. But maybe it's just a division of labor about what circle of population you're going to be worried about in terms of your local policing, your social services, and maybe that is informing the federalism.
Well, I'll start just by saying that I think that my own inability to draw a line that I could find any principle support for between the two, between what the spheres that you're defining for federalism. I don't know what it means. I couldn't figure out what through the cases and situations what it really meant to worry about the people in your jurisdiction, and how that is really distinct from the possible use of that as an indirect way of expressing immigration policy. It's really the essential. I couldn't figure out what the difference is ultimately. I couldn't think of a situation where states always can figure out a way to use alien law to achieve immigration law ends, and I think it was my frustration with that. And then, as you know, I didn't mention Tyler, but the whole first chapter, the whole intro of my book is like, the whole book is actually about Filer, in a way.
I'll just quickly, I'll just concur. I think the problem is you need a model which makes a line between the population you just deal with yours that doesn't lead into migration decisions, whether to come or lead into a jurisdiction that makes it probably impossible to really, for us the court to consistently regulate that line is part of the challenge. Kenyon.
They haven't been an actual software model, but I'll save that for the next panel. Hiroshi, did I hear you correctly when you were saying that states have no business questioning the way in which the federal government is making those laws and so on? But that puzzles me. And if you meant that, I have a specific question about Steve Bannon.
Hear the question?
Yeah, I was gonna say no, but I mean, because my answer, okay, I meant for the purpose of preemption, I think that the states have the power to question the making of federal law, but I think they have to show that it doesn't qualify as legitimate federal law. So in that sense, I think that the move that the state of Texas made in the DACA case was the way to go. That is to say that that there is an internal federal setup about whether you should go through notice and comment into the APA. And so their argument was that those requirements apply, the federal government failed to apply, therefore the law should be struck down. That would be the way to go. Well, absent that determination, that's what I meant. I'm still
So you agree that the state would have standing to challenge something like the president improperly delegating authority to?
And that, yeah, and I have to say that I'm probably less troubled by the standing implications of the Fifth Circuit decision than some other people, because I do think that it stands to reason that I think it's necessary, or a supporting implication of the way I'm looking at things is that there ought to be a way to challenge federal law as not qualifying as legitimate. And so that would allow states to do this, but absent that challenge, I do think that if it is a federal matter, and they rely on the federal authority since really the end of the Civil War, I would rely on federal authority to say that it's preempted absent that challenge. But I think I'm very sympathetic to the idea that should be challenged. The challengeable. Yeah. I mean, sorry about the question, but I'm not speaking. Okay. You're on next page.
All the way in the back.
So I was very interested in the theory about the lower level officials kind of interplaying with the higher federal orders and things. That came out recently, where officials in airports were reported to have continued following an order despite a judicial mandate and things like that. And we also know that in recent administration, some people have resigned simply for whatever reason. Do you see that theory in the next 4 years? How do you think that may play out? Have you thought about that? Have you considered that for the next 4 years? Or is there a chance that basically other people will just dissipate and then it'll be a one line, straight from the top to the bottom?
Yeah, so it's very hard to make predictions about this. It's part of the reason why I wanted to focus not only on these lower level influences, but also how that's an entree to thinking about vertical separations of powers. Because, as I said, and to some degree this goes to the idea of a direct challenge to an executive order as being properly, is it real, is it really law, or is it not law? There was a question earlier about the idea that through executive orders, basically the fabric of the administrative state would just be gutted, and what are the implications of that? I mean, of course, the idea of lower level influences to me is an important part of a series of checks within the executive branch, and so I can't predict exactly. I actually think the second part of what I talked about, which is these opinions that are beginning to give life and meaning and language to it's, again, we don't quite know what it is, the norms, if you will, of the way that executive branch law is made. To me, that is language, right? Can you just mint an executive order that hasn't gone through the ordinary channels of OLC review, etc.? Can you take action for which your relevant cabinet officials have not been consulted and are surprised? There's no doctrine that we can cite there, but the language around those opinions, to me, and I hope this is responsive, are the best to me, those are the best predictors of what the kind of legal response to these new executive orders will be. More perhaps than the role of lower level enforcers, one at a time, either deciding to go along with it or not to go along with it. The two can go together. In the 9/11 context, it was very interesting to to see some kind of almost symmetry or correlation or something between decisions by JAG Corps officers, by judges in the Guantanamo trials, by other officials within the executive branch not to participate in a detention scheme, in a military commissions scheme that was so far outside what they were accustomed to under the proceedings under the Uniform Code of Military Justice, etc. And the way that those kinds of decisions, not explicitly referenced in the Supreme Court opinions, but had a kind of correlation with the Supreme Court's continually talking about kind of long-term values and long-term roles. That's the closest that I can try to bring those two together, so I would look to those 9/11 opinions as well, in addition to what I just said, for some predictive value, and that's, I think, as far as I can go in answering that question.
Please join me in thanking our panelists. So I believe we still have coffee and pastries outside. We'll reconvene at 10:45 for the next panel on law enforcement and policing.